Good afternoon, everybody. My name is Brian Tully. Thank you for joining us once again for our Wednesday webinars. Today is a interesting topic, a more of a niche type topic, talking about college-age children going off to college, turning 17 to 18 years of age. And we're going to get started and talk about that a little bit today. Thank you for joining us, but let's give a minute for other people to log on, all right? So I'll be right back. All right, everybody. Am I off mute? I am unmuted. All right, again, thank you for joining us. My name is Brian Tully, and this is our Wednesday webinar series. We do this as often as we can over here at Tully Law Group. Today's topic is don't let your child leave for college without these documents in place. This is something that I've lived through personally and taken care of course. And it's important for those that we love and care for to also know about these risks and these ways to avoid and minimize the risks, all right? Like always, if you can please just put something in the chat box or the Q&A box to let me know that you can hear me and see the PowerPoint, most importantly, as well. So if you could just give me a thumbs up or say yes, that way I'll know we're good. Anyone? Can you hear me and see my PowerPoint? If somebody can just please, there we go. Thank you, appreciate it. All right, so talking about planning ultimately, because as an elder care and estate planning law firm, we work with families, we work with individuals of all ages, all shapes and sizes. And one of those shapes and sizes, if you will, is younger adults. And there's an often communicated misunderstanding that planning is just for older folks and for those with money, and that is absolutely not true. And we'll talk about that a little bit today. Also, I'd be happy to answer any questions. So this is not going to be a very long presentation, so we'll have time for questions if you have them. You just put them again in the chat box or the Q&A box, and we'll get to them at the end. Last housekeeping point. We've done a lot of webinars over the last 4.5 years. If you go to our website, tullyelderlaw.com or tullylawgroup.com, you'd be able to see under events and videos all of our past webinars that talk about all of these different types of estate planning, elder care concerns, asset protection, long-term care, estate taxes, marital planning. We cover all of them in past webinars, and of course, we'll cover them as we move forward as well. So please make sure you are on our mailing list as well. So here we go. First and foremost, why are we actually talking about this? So why is this a thing with our children? And it's been happening for generations. Our children graduate high school and then they get a job, they go off to trade school, they go to college. It applies to all of them. But the reality is that when our children are younger, we as the parents are the ones to make decisions about their health care, and we are the ones to make their decisions about financial choices. However, once an individual turns 18 years of age, that is the age of majority. And a person is legally considered an adult, which means you, as the parent, if you're the parent, are no longer their legal guardian for decision making. That means they make their own healthcare decisions, their own financial decisions. Whether they are actually what we would define as an adult, well, that depends to be seen on other factors, responsibility, paying your own way, etc. But legally speaking, 18 years of age. And then what happens again? Most of them go off to college. We've gratefully, in our family, we've been blessed to have two kids already graduate college. So this is my wife and I here with our eldest. This is Daniela. She graduated Penn State University 2 years ago, back in 23, or last year, I should say. And then here is Gregory, who graduated Syracuse University this past May. And when they went to college, they were adults. But what happens is at college, right? What happens at college? We see a lot of this, or we hear about this, or perhaps we've experienced it ourselves, or we've seen movies that talk about these things. And it's not just the partying and the craziness. There's sports, there's other activities, and other things can happen to our children when they are adults and away from us. And unfortunately, they may end up in some type of with some type of an injury or traumatic event and end up in a hospital. The reality of it, the statistics are that young adults 18 to 24, over 1 million kids are injured in sports. Now, I'll say gratefully that's usually bones and tendons and ligaments, but it could also be head injury as well. In addition to that, over 567,000 college kids were involved in car accidents by the year, and you can average that out. But that's hundreds of thousands of kids, 1.5 million altogether, injured through sports or injured through car accidents. And not to mention alcohol-related injuries, slips and falls, unintentional alcohol poisoning, unintentional drug overdoses. God forbid these things occur, but we all know that they can happen. Bottom line is that in college, as with any adult, any person, there are risks. And the concern becomes that if your child is off of college, even if they're, dorming here at Hofstra or Stony Brook, whether they're local or they're further away, what happens if an event occurs with your 18-year-old young adult child, right? And unfortunately, it's the same story. So whether somebody is 18 or whether somebody is 88, if there is, God forbid, a loss of mental capacity due to injury or illness or accident, again, what we just saw, the partying, the accidents, the car accidents, the sporting events, if there is a loss of mental capacity, and there is no planning in place, no legal documents in place for decision making, then what must occur for any adult is what's called a guardianship proceeding. So it looks like this. Again, doesn't matter if you're 18 or 50. If a person declines in mental capacity, again, through injury, illness, dementia, cognitive concerns, sporting activities, doing something stupid, as I know some of us have done, if they're no longer able to handle their financial affairs and they're no longer able to handle their personal affairs, what happens is a interested person or a loved one, a parent, a sibling, a spouse, would step in and petition the court in what's called a guardianship proceeding. So again, if there's a loss of capacity and there's no legal documents covering that, then there is only one route for somebody to help, and it's called a guardianship proceeding. You would literally have to generally engage a law firm and petition the court and say, Judge, this has happened to my loved one, and they are unable to handle their financial affairs. they're at risk of jeopardizing their financial accounts, their financial assets, their personal health. They can't make decisions in a medical setting. They can't make decisions in a financial setting. So, Judge, I need you to declare them incompetent and appoint me as a guardian of the person and a guardian of the property. The guardian of the person can handle the health and living decision making, and the guardian of the property makes the financial decisions. So again, the injury, illness, accident, that is the worst case scenario. If there is no planning, no legal documents in place appointing you to help, then that's adding, if you will, insult to injury. And then you have to go through this guardianship proceeding to be appointed by the court to actually have the legal ability to make decisions for that person. Guardianship should be avoided at all points, and that's really the thrust of this seminar. We want to keep our families out of court, keep them out of a guardianship proceeding. You're looking at about anywhere for initial, what are called temporary authority, about 2 to 3 months, upwards of about 6 to 8 months, and longer, God forbid, if there's any type of contest or challenge during the court proceeding, before this is finalized. In addition, in addition to the time delays, you're looking at the judge appointing other attorneys to be involved to interview and to conduct some discovery and find out what the facts are, who the family is, and make recommendations to the judge as to who should actually be appointed the guardian. So just because you're the one applying for guardianship doesn't mean the judge is going to appoint you. Once you start this proceeding, it is out of your control as to who the judge appoints. All right. Generally they will pick, of course, family if it's appropriate and it's the right person. But it's not guaranteed. We've seen remarkable things within the guardianship court. Once a judge is in charge of that scenario, it can go different ways. So we have time delays. We have other attorneys being appointed and getting involved, which means hourly billing, which means increased legal fees. A guardianship legal fee can be anywhere from $5 to $10 to $15 to $20,000, depending on the complexity of it, right? Another reason we want to avoid all this. And then finally, the quote softer reasons is just the emotion of it and the stress of it. Wouldn't it be so much easier just to have a legal document in your drawer that would allow you to make legal decisions or financial decisions or healthcare decisions, and you wouldn't have to do this? You wouldn't have to go through this court proceeding. Again, adding insult to injury because you're already dealing with the issue that your loved one's going through. So this guardianship is there as a backstop. If the planning isn't done, the law allows us to pursue this in the worst case scenario. And I'm telling you from firsthand experience, you do not want to go this route. You want to go the other route. You want to be prepared, all right? Which is why we're talking about this in July before your children go off to college next month. Now, believe it or not, your 18-year-old going off to college is an adult. Estate planning has a lot of different connotations, but the true reality is estate planning is for every adult. And the picture you have here, you've got 3 generations. The younger person there looks like he's going off to college, and there you go. So it applies to them. Estate planning applies to every adult over 18. So it's not just for senior adults or the elderly. It's not about net worth and assets, because a kid going off to college, maybe there's a joint bank account with the parent, right? Or they have their own bank account. This stuff still matters. And it's not about the health that you're in. Estate planning is not just for those that are starting to get sick or have been diagnosed with something. This is what you should have in place, just like homeowners insurance, right? You don't ever want to use it, but you need to have it in place just in case. In essence, and big picture, estate planning is for every season of our lives. We're focusing today on the young adults, the college-age children. But as an elder care and estate planning firm, and I've been doing this for over 26 years, what you're looking at is there's a generally a plan that's appropriate for every age group. So when we look at those younger, 18 to 40, college, starting career, starting family, there's planning that should be in place for that age group. You start looking at 40 to 60 years of age, that's where they're expanding their assets, expanding their family, growing their assets. Then you get into the phase of 60 to 80 years of age. Again, more specific planning is recommended depending on age and health and assets. And ultimately, a big part of our practice is on the elder care side, which again could be almost any age, but you start looking at 80 to 100 years of age, once again, specific types of planning and strategies. It all starts when you become an adult at 18 years of age. There's a prudent plan that should be in place for an 18-year-old. So when people say, well, estate planning, again, big picture, estate planning has to do with these 5 different issues. Of course, I understand age will dictate a simpler plan, right? A younger age. A more complex net worth, higher net worth would dictate a more complex plan. So all of that goes into play. But generally speaking, when we talk about estate planning, we are talking about inheritances. All right, we're talking about who's going to inherit, what are they going to inherit, when do they inherit, and how do they inherit. Again, topics I talk about in other webinars, or we could talk about, we offer free consultations to talk about these things. Estate planning also has to do with health. That's generally where that elder care component comes in. It's your medical needs, it's your long-term care needs, which are the abilities and the cognitive abilities as we age. A very important portion of estate planning is avoiding the courts. We just spoke about guardianship and how that really should be avoided and not utilized unless it's a true crisis. But if you follow our philosophy and what I'm sharing here, every adult 18 and over should have planning in place that avoids the guardianship, okay? And then that word probate right there. We'll talk about it a little bit more later, but that's a court proceeding when somebody passes away and they have assets in their name alone. They have assets in their name solely. That court proceeding, like guardianship, will be necessary because nobody has authority over those assets that are solely owned when a person passes away. Avoiding probate will save time and save money, just like the guardianship, but it will also keep the family affairs private. The probate courts, or as we call them in New York, surrogates courts, and there's one in Riverhead in Suffolk County, there's one in Mineola, of course, Jamaica, Queens. Every county or borough has their own court that handles these proceedings. It's a completely public proceeding. Keeping the family and the assets and the addresses and the ages and their health out of the courts, out of the probate courts in particular, keeps things private within the family. So probate avoidance is always a goal within estate planning, and often so is asset protection. Not generally for college-age children like we're talking about today, but maybe their grandparents, right? You start looking at, wow, I'm 60, I'm 70, I'm 75. Is there a need to protect assets in case I need long-term care later? I don't want to lose the house to the nursing home. I don't want to lose the house to New York State, that type of thing. And ultimately, the financial aspect of estate planning. Taxation is significant. We know that. So estate taxes, gift taxes, income taxes, which includes capital gains taxes, that's all a very important part of estate planning, okay? So again, today's focus is on college age planning. So what I'm going to do is kind of get back to that point, but I just wanted to share the big picture. Now, generally speaking, there are 5 basic foundational, let's call them foundational documents that we want our clients to have. And I'm going to say regardless of age, regardless of money, and regardless of health. But this is not a boilerplate. This does not apply to every single person. And as we talk about the college age in a moment, we're gonna dwindle this down a little bit, okay? But generally speaking, an estate plan includes a last will and testament, right? We've all heard about a will. That's the document, however, that requires that probate proceeding we don't want, but you still need to have a will just in case. Then we get a little more practical and particular to today, the idea of a power of attorney, which I will talk about more at length in a couple of minutes. A healthcare proxy, again, to be spoken about more today, and ultimately a living will. That's an end of life statement, not to be confused with the last will and testament, and not to be confused with what we provide called a legacy will. A living will is an end of life statement that, in essence, says, I do not want the machines to keep me alive artificially. All right. It's a discussion to have, with your spouse, with your family, and then we can implement what those wishes may or may not be. More and more, the fifth foundational document is going to be a trust. Really, again, two primary reasons, which I've already mentioned: avoiding probate and protecting assets. So trusts come into play more and more these days. As the world gets crazier and crazier, and the courts have more and more delays and more costs, trusts become much more important in the vast majority of plans. Okay, so when we're talking about estate planning, it's generally these five foundational documents. Always strategies can be added or removed. But in particular, when we talk about college age children, generally speaking, we don't need a last will and testament. Okay. Generally speaking, we don't need a trust. Generally speaking, we don't need a living will. What we focus on with our college age children, and quite honestly, the way this happens most often is we're doing estate planning for the parents or the grandparents. And the reality of probate and the reality of guardianship and the reality of stuff happening causes the parents or the grandparents to say, hey, what should I be doing for my 20-year-old? What should I be doing for my grandchild that just graduated high school? So what I'm going to say here is there are two must-haves for those that are college age. And of course, we prefer them at 18 years of age, as soon as they become an adult. And that's going to be the power of attorney and the healthcare proxy. My two children you saw earlier, Gregory and Daniela, before they went off to college, now of course I do this for a living, so I knew about it, and that's why I'm trying to share it with you. Power of attorney and the healthcare proxy. I would say those are must-haves. I would say those are requirements before your children at 18 years of age leave the house for college or trade school or what have you. All right. You hit 18, you get these documents in place. So let's talk about them a little bit more. Now, power of attorney. I will say, if you're walking around my office, you will hear this several times a day. The power of attorney is the most important planning document there is. All right. Period. In essence, it's where you're appointing somebody to handle your legal and financial decision making. Okay. So therefore, if God forbid accident, injury, illness, and there's a loss of capacity, a loss of ability to pay bills or to take care of your financial and legal affairs, the power of attorney agent that you've appointed in this document is standing there empowered and legally able to act on your behalf. This is the primary way to avoid that guardianship mess I spoke about earlier. Okay? The power of attorney. Now, let me give you some more specifics, because not every power of attorney is equal. They are different. Where you get the power of attorney matters. What language is in the power of attorney matters. What form you use matters. All right. So New York State hasn't made this easier on us. They've changed the law 3 times in the past 15 years. So when we're talking about a current, effective, valid statutory power of attorney, it has to be the 2021 form. All right. There was an amendment back in 2021. That's point 1. Point 2, the principal, which is the person signing, your 18-year-old that's signing the power of attorney, they are called the principal, and they are appointing a person to help them called an agent. Okay. And there can be more than one agent. So it could be, if we have Stephen going off to college, he can pick mom and dad as the power of attorney agents, and they can work together, or they can work separately, but you could have 2 people. And we always build in a successor, by the way. But that agent is a fiduciary. That means they must act in the best interest of the principal that appointed them. They can't do things to benefit themselves over the principal. Okay, so it's a fiduciary relationship. As I've stated, it's legal and financial affairs. A power of attorney is not healthcare. All right, that's why we have the proxy, which I'm going to talk about next. This is about legal and financial decisions. The power of attorney, now to get a little more technical, these 2 points are crucial. It must be a durable power of attorney. There are some powers of attorney that are considered general powers of attorney. They are not necessarily durable powers of attorney. A durable power of attorney is where the power of attorney and the appointment of the agent remains valid and effective even if the principal loses mental capacity, which may be a little confusing because we're talking about the scenario where the principal loses capacity. But understand, years and years ago when this was first created, if I sent somebody to go handle some business for me, but then I lost capacity, that agent of mine also lost the capacity to handle my affairs. It's just how it used to be, and it is how it is in a general power of attorney, which is where the idea of durability came up years ago. Durability means that that document is stronger and durable and remains effective even if capacity is lost within the principal. This is what you have to have when we're talking about estate planning. Okay, so a durable power of attorney. Next, just as, if not more critical, the power of attorney has to have modifications. The standard New York form, the 2021 form that they put out there that I mentioned earlier, that form does not have all of the necessary powers that have to do with estate planning and with aging and real estate and healthcare authorities. Doesn't deal with retirement accounts very well. It's a very bare bones document. So if you go to a real estate attorney or you go to your personal injury attorney and they print out a power of attorney from the Bar Association, it's not going to have those modifications. If you go to an online, and there's several of them, I'm not going to start mentioning them. If you go online and purchase a power of attorney for $99, it's not going to have these appropriate modifications for estate planning purposes. So what we do is we take the standard form and we push in there all of the modifications that we've seen as necessary and appropriate for people as they age, asset-wise, retirement account-wise, employment-wise, real estate-wise, long-term care-wise. There's modifications in there to cover every scenario, okay? If the modification doesn't exist, if it's not in there and it's needed, guess where you're going? Back to that guardianship court, okay? So we literally, or I should say figuratively, throw in the kitchen sink, okay? We want our powers of attorney to be durable and to have as many modifications that may arise in the future, okay? All of this, as I've said several times, is to avoid that guardianship court in the future. God forbid something happens to your college-age child. God forbid something happens to an older family member. Because again, we're all adults at this point. Once we hit 18, it's all the same. Doesn't matter if you're 18 or 80. If you lose capacity, the family is then scrambling to handle the financial and legal affairs. And that's where the guardianship court comes in, which we want to avoid. And this modified durable power of attorney does that. To reiterate, please don't do online forms. There have been some judges, I don't think it's in New York, that have actually disqualified and thrown out online forms when there's a challenge because they don't meet certain criteria. When you're purchasing an online form, it can be generated in another state. They can say it's valid in New York or New Jersey or Connecticut, but how do you know? How do you know? So when you sit down face to face with an attorney experienced in this area, licensed in the state where you are and where your children are or your parents are, that's going to be an appropriate form. That face to face, having the documents built and tailored to what your specific needs are, is certainly worth, in our experience, certainly worth the cost it takes to get it done. So power of attorney, must have document for kids going off to college. The next one is healthcare proxy, is the healthcare proxy. So God forbid, picture this. You're looking at a scenario. There was a time, there was a time when I ended up in the hospital when I was in college back in 1988. May have been the spring of '89. Um, yes, I had done something stupid. Yes, I was in a hospital. Gratefully, I did not lose capacity. I was able to still talk and communicate, but my parents didn't know where I was for a day. All right. So things happen. There's a whole spectrum of events. It could just be this or it could be more extreme, but things do happen. And gratefully, I was able to communicate to the doctors what happened and what type of treatment I did want and didn't want. But if you're not able to communicate, okay, then you have this form. All right, your parents are holding this form, and you, as the parents, have all this. And when we provide them their digital PDF forms as well, we'd recommend you have them on file at the hospital in that college town. And this healthcare proxy is where it says, okay, mom or dad or sibling, aunt, uncle has the ability to make healthcare decisions for me if I can't do it myself. Okay. So as long as I'm able to make healthcare decisions, I do it. But if I can't, this is the person I want to do it for me. All right. And it can only be one person at a time. That's how this form works, unlike the financial power of attorney. So the healthcare proxy, one agent at a time, but you do have a successor. So there's a person underneath, a number two, if you will. The healthcare proxy should have built-in HIPAA provisions. That's Health Insurance Portability and Accountability Act from 20 years ago. That's a privacy release. So your agent can also access all of your medical records. All right, that should be built into the proxy. The New York State form does not have that in there. In addition, the New York State form does not have the appropriate sentence that deals with artificial hydration and nutrition. We have clients come in here all the time with the New York State form, and it's missing the privacy release, and it's missing the statement that says, my agent knows my wishes about artificial hydration and nutrition. If that sentence is not written in there, then your healthcare proxy agent cannot make decisions about feeding tubes. Okay? Has to be built in there, and of course, ours includes that. Finally, when we're talking about the healthcare proxy, it's important to realize that unlike the power of attorney, there is a healthcare law, gratefully, and it's relatively new. It's called the Family Healthcare Decisions Act. And what that says is if there is no healthcare proxy, the law allows these people in a hierarchy order to make healthcare decisions for you. Now, what does that mean? So if God forbid something happens and a person is not, and again, right, any adult, if any adult loses mental capacity and can't make decisions about their health care, ideally you have a healthcare proxy that says, I pick person A first and I pick person B second. You're in charge, you pick who you want to do what and when. But if you don't have that form, you do not immediately have to jump to the guardianship proceeding like you would if you were lacking the power of attorney with the modifications. So what this Family Healthcare Decisions Act says is that a spouse can make a decision for a spouse. A parent can make a decision for a child, and then so on and so on and so on. And a child can make a decision for a parent. But let's reverse the roles here. Let's say we have a parent who's 80, and there's a child who's 60, and a child who's 55, and a child who's 50. Who's the best child to make the decision for that parent? Or again, reverse it. Let's say we have an 18-year-old, and we have two parents that are divorced or estranged, and there's a better relationship with one than there is with the other. Those parents are equal. Those parents are equal. So wouldn't it be more prudent and smarter to actually have a document that says, I pick dad first, I pick mom first, or I pick my middle child to make these healthcare decisions for me? That's why the proxy is so important. Please don't wave this off just because there's a list in a law somewhere that says, oh, there's somebody named. You want to be careful as to who you're picking to make those decisions. And you actually want to have a conversation with that healthcare proxy agent. You want to have a conversation so they understand what your wishes are. What do you like? What don't you want to have happen to you? And that's where that living will comes into play. God forbid you're talking about end of life issues, okay? But have a conversation with the person you're picking as your healthcare proxy agent about respirators, about ventilators, about feeding tubes, about end-of-life issues, okay, about pain relief. It can be laid out in a written living will, or you can have that conversation with the people you're picking on the healthcare proxy, okay? So once again, healthcare proxy, power of attorney, those are the two must-haves. That's the minimum for kids heading off to college. One last word to the wise here. I've mentioned this several times, and this is important. My kids went off to college. They had joint bank accounts with my wife and I. That's how it works. We have access to those accounts. If God forbid there's an incapacity, or even worse, we have access to that money. It's not locked in their name alone. Because if it is locked in their name alone, like I've said several times, we then have to go to court for a probate proceeding if they've passed on, or guardianship proceeding if they're still alive and there's no power of attorney. On the point of probate, though, in the worst case scenario, make sure the kids' accounts are joint with you, or have beneficiaries, or are owned by a trust. Because if it's solely owned, then you have to go to that court proceeding called probate, okay? Again, just last minute word to the wise. So here we are talking about our children turning 18. And by the way, I still have one more to go. She's 11. So we've got a couple more years to go. But I assure you, when she turns 18, she'll have these documents in place. So what we're offering here, and again, this normally comes up in a scenario where we're sitting with the parents and they're like, oh boy, my son just graduated high school, or my daughter's starting freshman year of college. What should we do? So that's typically where it happens. What we're doing here, though, is saying, listen, of course your parents should have planning, or you as the parent should have planning, but we're focusing on the kids directly. So $500, one flat legal fee, and we would provide that modified durable power of attorney and that healthcare proxy. All right. So they can go off to college. You have the documents knowing I'm able to help if, God forbid, things go south. All right. I can make decisions financially, legally, and healthcare wise. The one catch, because the summer is going pretty fast, is you need to contact us and you need to talk to us and meet with us and hire us, engage us before the end of July, so that we then have 2 weeks to put the papers together before they leave. We've had rush crisis cases. We don't want that. We want to be able to take our time and get it done right for the family. So reach out to us. This is the fee that we would charge per child, and we will get them done before they go off to school. I do hope this was helpful for you, shed some light onto the need for estate planning, even for younger folks. And of course, if you wish to do a last will and testament and the living will or trust, if that's appropriate, we could talk about that as well, because the 18-year-old is an adult. But let me know if you have any questions. I'm here to help and direct on this as much as I possibly can. We do offer free consultations, as I've shared. You can email me directly, Brian at Tully Elder Law, or call us at 631-424-2800, 424-2800. As I said earlier, tullyelderlaw.com or tullylawgroup.com. That will bring you to our website. You can learn more about us and our services and see past webinars that talk about different aspects of planning. Any questions? I'm happy here to answer any questions at all. All right, so anybody have any questions so far? I don't see any, which is fine. So hopefully this was clear enough. Okay, good question. So question comes in, do we only do students attending college in New York? So that, great point. It comes down to where is the person a resident, right? So if your children live with you here in New York, that's what counts. Now, if a parent or another adult moves to another state, then you got to look at getting documents updated or reviewed in that other new state. But if they live in New York with you, then yes, the New York documents are appropriate to have. Any other questions? Any other questions? All right. Again, thank you for joining me. We'll be doing one of these, if not two of these, as we move forward during the months. We look forward to seeing you soon. Enjoy these nice warm days, and you'll be wanting them in December, January. And again, thank you. All right. You're welcome. Bye-bye. Where's my thing? There we go. All right. Thank you very much.